This is part 3 of Federalist 78. I'll start with paragraph 9. This is the first time that he actually brings up the concept of judicial review. Just keep in mind that in part 1 and 2, we talked about one of the ways that the Judiciary Department can be independent from the other branches is by giving the federal judges the letting them serve for life or during good behavior, as the Constitution says. Just remember that the idea came from the British system, and back then, for the longest time, the judges served during the king's pleasure, till eventually the judges actually could be removed by the two houses of parliament in early 1700s. But the term is just a continuation of that term, so they were placed during the king's pleasure to during good behavior. So that's one of the mechanisms that you make the judiciary independent. Okay, I'll start reading paragraph 9. The complete independence of the courts of justice is peculiarly essential in a limited constitution. Peculiarly here does not mean strange. Here it means specifically, especially. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. There are certain things in the Constitution that the legislative branch cannot mess with. Such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. See, this is the first time the phrase is used. Without this, all the reservations of particular rights or privileges would amount to nothing. So one of the things that you will come across in the next few papers is that the anti-federalists were saying, wait a minute, we need a Bill of Rights. There are only a few things in the Constitution that says the legislative branch cannot mess with, like no bills of attainder, no ex post facto laws. They said we want more guarantees. And Hamilton keeps on saying, no, it's not needed. Nobody's going to violate your rights. That's why I say, when you read these Federalist Papers, focus on the body of the Constitution. Before the first 10 amendments came, this is the body that was written, Constitution that came out of Philadelphia. And that's why I said in part 1 that half of the first 10 amendments actually have to do with the shortcomings of the original Constitution in dealing with people's rights, in dealing with judiciary. So keep that in mind. The next paragraph, some perplexity respecting the rights of the courts to pronounce legislative acts void because contrary to the Constitution has arisen from an imagination that a doctrine would imply a superiority of the judiciary to the legislative power. It is urged that the authority which can declare the acts of another void must necessarily be superior to the one whose acts may be declared void. As this doctrine of great importance in all American constitutions, a brief discussion of the grounds on which it rests cannot be unacceptable. It says to the people, to the anti-federalists that are saying, just because the judicial branch can say the legislative branch's acts are constitutionally null and void, it makes them superior to the legislature. He says nobody's saying such a thing. And he says it's important enough that let me just expound on it. Let me talk a little bit about it. Then he goes on to say, there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than the principal, that the servant is above his master. Who's the servant? It's the representatives to the House of Representatives. It's the senators. It's anybody that works in the government. It's the servant of the people. That the representatives of the people are superior to the people themselves. That men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provision in the Constitution. So you can't let the legislative branch do whatever it wants to and be the final judge of whatever they say it's constitutional or not. This doesn't make sense. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. So representatives cannot pass laws and say this is superior to the will of the people. Where is the will of the people reflected in? It's in the Constitution. Because the whole body of the people decided on the Constitution, ratified it. So that becomes the supreme law, the fundamental law. Even though the legislatures are elected by people, they cannot put the laws that they pass above the fundamental law, the supreme law of the land, the Constitution that was ratified by the people. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority, keep the legislative branch in its place, keep the administration, the executive branch in its place. The interpretation of the laws is the proper and peculiar province of the courts. A constitution is in fact, and must be, regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought of course to be preferred, or in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. Nor does this conclusion by any means suppose a superiority of the judicial to the legislative power. It only supposes that the power of the people is superior to both, and that where the will of the legislature declared in its statutes stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter, by the Constitution, rather than the former, rather than the legislative acts. They ought to regulate their decision by the fundamental laws, rather than by those which are not fundamental. Fundamental laws are the Constitution. The exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in whole or in part with each other, and neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation, so far as they can by any fair construction be reconciled to each other. Reason and law conspire to dictate that this should be done. Where this is impracticable, it becomes a matter of necessity to give effect to one in exclusion of the other. The rule which has obtained in the courts for determining their relative validity is that the last in order of time shall be preferred to the first. But this is mere rule of construction, not derived from any positive law, but from the nature and reason of the thing. It is a rule not enjoined upon the courts by legislative provision, but adopted by themselves as consonant to truth and propriety for the direction of their conduct as interpreters of the law. They thought it reasonable that between the interfering acts of an equal authority, that which was the last indication of its will should have preference. Notice in this last part that I read, I did not talk much about what was called the common law that was inherited in the United States and kind of helped shape, in a way, the law and the judicial system and interpretation of the law. That's why I introduced some of these books to you that they talk about common law and they give you the background of it. An example is like a couple of articles in this book that I mentioned to you, Saving the Revolution. When and if you can, take a look at those and I'll just give you some more in-depth ideas. Or look at some of the newer articles and statements by scholars in places like the National Constitution Center.